Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I have the wrong chat up. I have last night's chat up. Oh my gosh. Give me just a second here. Woo, don't worry. We'll be right there. We will be right there. I just got to fix the chat. It occurs to me that I completely forgot to do it. So here we go. Okay, there we go. There we got it. Sorry about that. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, we have a big update in the Derek Chauvin, George Floyd ongoing murder trial in Minneapolis. And the update is not about what you've probably been watching, which is jury selection. Although this news is coming out of today's jury selection hearing. It is not really the part everybody's focused on. People are asking questions about what's going on with picking jurors. I'm not really talking about that today. We are talking about the big news that third-degree murder has been added back to Derek Chauvin's case. Now, this is over a fight over third-degree murder that happened between the prosecution and the defense. Here's the long and short summary of this, okay? So, when Derek Chauvin was first charged, he was charged with second-degree murder, third-degree murder, and second-degree manslaughter. Okay? So, then the defense moved to dismiss the third-degree murder charge, saying that the third-degree murder charge does not apply in a case where the actions are directed at a particular person. And they have quite a bit of Supreme Court precedent to support the argument. We're going to get into that in a minute. The prosecution appealed that decision. The judge said, yeah, we're going to dismiss this third-degree murder charge because the defense is right. This can only apply, third-degree murder can only apply with the endangerment of more than one person. The prosecution appealed this. It went to the Minnesota Court of Appeals. And part of the reason why this was up in the air for so long is because the reasoning that, how do I describe this adequately? The reasoning used to reinstate the third-degree murder charge was based on a recent decision back February 1st, I believe, from the Minnesota Court of Appeals in the case of Mohammed NOOR. He is the police officer in Minnesota who shot the Australian immigrant Justine Demond from his squad car, from the passenger seat of his squad car. He pulled his gun, fired across his fellow officer and into Justine Demond. And he appealed his third-degree murder conviction, saying that he could not be convicted for third-degree murder because his actions were directed at one particular person, which goes against the concept of third-degree murder. The Court of Appeals disagreed with that argument, and they said that no, you can actually direct your actions at a particular person so long as you fill the other elements of murder 3. So right now there's an argument over whether or not the actions in third-degree murder can be directed at a particular person, okay? That's the issue that's going on here. That's why this is weird. Chauvin's argument against third-degree murder would be that he directed his action, though it was not intended to kill or anything, but he directed his action only towards George Floyd and no one else was in any sort of danger. Therefore, third-degree murder can't apply under this particular interpretation. But again, the Minnesota Court of Appeals said no in Mohammed NOOR's case. Now, the judge justified his decision over that appeal. He said, well, the Minnesota Court of Appeals their decision in Mohammed NOOR is not binding precedent because that decision has been appealed further to the Minnesota Supreme Court and they haven't issued their decision. the Minnesota Court of Appeals did not like this argument at all. Okay. And trust me, if you go into a court and you argue that their decision doesn't matter when a higher court hasn't told them that their decision doesn't matter, you're not going to be on friendly ground. Just going to, as a rule, I mean, you might be right, but you're going to have to overcome a very unfriendly sort of approach to questioning the court's authority over you. So the Court of Appeal said, actually, dummy, our decision is binding precedent on you, and you will overturn your order and reconsider third degree. Now, it didn't mean that third degree was added at the time. It meant that they demanded that he reconsider third degree murder consistent with their precedential opinion in State versus NOOR. Today, the judge decided he would add that third degree murder charge based on that precedential decision in State versus NOOR. Okay? That is the procedural background of where we are. That's a very important thing to note. What this does not mean that the state will definitely secure a conviction under third degree murder or second degree manslaughter. Right now, there are good odds that Chauvin ends up walking from this. There are pretty good odds that he ends up getting convicted on one of the three charges. It's a messy case that involves people and publicity, and that is not an adequate experiment for proper application of law ever. Proper application of law is done on motion papers only in a court in a case where no one's heard anything about it. This is about the messy, real application of law that happens when we have a jury system and a jury is allowed to say no to the state for whatever reason they want. So there's some weird stuff going on, but this does not mean that he will be convicted. I am not making an argument for the guilt or innocence of Derek Chauvin. I am watching with all of you. What I'm going to do today is we're going to read through very quickly a section of that State versus NOOR case to look at why the Court of Appeals decided to apply third-degree murder in that case, and then apply those discussions to why third-degree murder could apply in this case and why it should be on the menu. I have always been of the opinion that of the charges for murder, first, second, or third degree, that third degree is the only one that I think they can reasonably expect to land on Derek Chauvin. And that does not mean that I think they'll get it. It just means that I think of the three, that's the most likely. First degree is right out. Second degree, I think, is out for problems of reasonable doubt with regards to the intent to commit an underlying felony act that caused the death of Derek Floyd. I think third degree murder is the most appropriate murder charge. So that's been my opinion from the start. Lots of people disagreed with me, and let me just suggest that I'm right. because based on the evidence that it's my opinion, I'm right. So that's an appeal to self-fallacy, and we're going to stick with it. So with that said, let's go into this very quickly, and we're going to look at why this third-degree murder charge was upheld in the Mohammed Noor case. I think a lot of people are confused as to why this was upheld. They're talking about other people being put in danger and stuff like that. And I want to dispel that as the reasoning that the Court of Appeals in Minnesota upheld that conviction. So here's the challenge with third-degree murder. I'll give you brief background on the third-degree murder challenge. Did I say Derek Floyd? Oh, my goodness. Here's the challenge with third-degree murder. The conventional wisdom, and if you watched Viva and Barnes' live stream the other day, Barnes talked about this specifically as to why third-degree murder shouldn't apply. And if you have listened to other lawyers, I believe Nate, the lawyer in uncivil law, have talked about this, why third degree shouldn't apply. The conventional approach to third-degree murder is that the act must be imminently dangerous to other persons. And that other persons is read as plural. So your act must be dangerous to more than one person. Not another person, but other persons, okay? So that is kind of the conventional wisdom for third-degree murder. Now, there are some cases in Minnesota history that have supported the idea that third-degree murder can have an act directed at a single person. Those have existed. They're going to be cited in this case. But generally speaking, the more recent case law suggests the opposite. The Court of Appeals draws a distinction between these cases, and I think that distinction is critical. But in the Mohammed Noor case, they did not decide that his acts were imminently dangerous to other persons. They specifically state that third-degree murder can apply when the acts are directed at one other person. The singular is the plural, and the plural is the singular, is something that we're going to see in this document. So, without further ado on the background of why this is difficult, let's read these couple sections about third-degree murder, about depraved mind, and we will see what their decision is, and then you guys can take that and apply that to your own thinking about this case. Again, this is entirely meant to be informative. It is not meant to persuade you towards guilt or innocence of any given person. I frankly don't care who's guilty or who's innocent in the grand scheme of things. I'm curious about how it turns out. So, all right. Section 6 and 7 on Westlaw, the particular person element of third-degree murder. So we're jumping into this case. By the way, if you have Westlaw, this is citation 317740 in 2021. I don't know if you can find it off of Westlaw, but here we go. Over 100 years ago, our Supreme Court stated that third-degree murder is, quote, intended to cover cases where the reckless, mischievous, or wanton acts of the accused were committed without special regard to their effect on any particular person or persons, but were committed with a reckless disregard whether they injured one person or another. That's citing State v. Lowe. This is a case from 1896. Seizing upon the language without special regard to their effect on any particular person, NOOR argues that a conviction under the third-degree murder statute cannot be sustained if the alleged conduct was directed at a particular person. NOOR contends that because the evidence shows that his death-causing act was directed at the person who appeared outside of the squad car, he cannot be convicted of third-degree murder. Several cases inform our analysis of the particular person issue. The first is Lowe, which is what we just read from, in which the defendant challenged his indictment for third-degree murder. The indictment alleged that the victim, Clara Berg, was pregnant, sick from blood poisoning and other diseases, and about to give birth. The defendant took Berg to a hotel room under the promise that during her sickness, he would provide her with necessary medical care. The defendant, however, neglected to provide the promised care, and Berg died. The Supreme Court concluded that a charge of third-degree murder was not appropriate, reasoning that the applicable third-degree murder statute was intended to cover cases where the reckless, mischievous, or wanton acts of the accused were committed without special regard to their effect on any particular person or persons, but were committed with a reckless disregard of whether they injured one person or another. We do not deem it necessary that more than one person was or might have been put in jeopardy by such act under the Penal Code. The singular number shall include the plural, and the plural the singular. It is, however, necessary that the act was committed without special design upon the particular person or persons with whose murder the accused is charged. The acts and omissions here in question are not of that character. They had special reference to Clara Berg. It was not a case where the act or omission did or could not affect any person or persons who happened to come along or be in the way or at the time of the act or omission. Okay, so the question then will be, under this reading, the question becomes, did Derek Chauvin have a special design upon the person of George Floyd? That will be an argument that'll have to come out in court, and that'll be interesting to navigate, because if he acted with a special design on George Floyd, it may rise to the intent or unintentional murder, but intentional, act required for second-degree murder. If he didn't act with special regard to George Floyd because he's an officer responding to a call, and this is the call. Not that the call was George Floyd, but that the call happened at all. If that's the argument, then he could be guilty of third-degree murder under this interpretation. This is not complete, but I just want to point out kind of some of the differences here. This case from that they're citing was a case where a person designed some sort of acts towards this particular person. The argument for Chauvin is whether or not he was intending this to happen to Floyd, intending his acts on Floyd, or whether or not Floyd was just the person who happened to be there when he arrived on scene. And I think there's a strong argument for that second one. So anyway, moving on. Lowe establishes that third-degree murder may occur even if the death-causing act endangered only one person. And again, this runs contrary to the conventional thinking on third-degree murder under current jurisprudence. And we're going to get there in a little bit. The second case is Mitic, in which the defendant was indicted for murder in the first degree and aggravated assault after she shot and injured her ex-lover and shot and killed his wife. Following a bench trial, the district court found the evidence insufficient to support a first-degree murder conviction because the state did not demonstrate intent to effect death. But the court found the defendant guilty of third-degree murder and aggravated assault. On appeal, the defendant argued that because, quote, fatal shots were directed with particularity, she could only be found guilty of second-degree manslaughter. The Supreme Court rejected that argument. The Supreme Court stated that, quote, the trial court was justified in finding that defendant was guilty of something more serious than culpable negligence. And then the citation provides that a person who caused the death of another by the person's culpable negligence is guilty of manslaughter in the second degree. The Supreme Court held that, quote, the fact that a person with a mental disturbance evinces a depraved mind by shooting and injuring one person and killing another does not necessarily mean that such killing was committed with such particularity as to exclude a conviction of third-degree murder. Each case must be determined on its own facts and issues. So here, the Court of Appeals is focusing on that last line, in that we shouldn't be blanket removing third-degree murder charges based on these broad sets of ideas. Each case must be determined on its own facts and issues. And it's important to note that the third-degree murder in this case was sustained when someone pointed a gun at a person and pulled the trigger to kill them. That was, well, maybe not to kill them, because it sounds like there was some mitigating factor that they weren't intending to kill. They weren't even intending to argue. It says a mental disturbance. So it's very possible that there was some mitigating factor. It doesn't really matter. The point is they directed their actions at one person who died as a result of the action. Okay? That's where they're latching on to here in the Court of Appeals. The third case is Hall, in which the defendant challenged her conviction of third-degree murder, arguing that the third-degree statute required the state to prove beyond a reasonable doubt that she lacked intent to effect the death of any person. The Supreme Court rejected that argument, concluding that the without intent to effect the death of any person clause of the third-degree murder statute does not require the state to prove beyond a reasonable doubt that the defendant lacked an intent to effect the death of any person. So this is a weird sort of idea, but let me reword this in a particular way. Okay? It's not, the state doesn't have to prove that they lacked the intent to cause the death of a particular person. The state just doesn't have to reach the proof that they did. Does that make sense? I know. It's kind of the catch-all, the net for when the state can't prove the specific intent to effect the death of the person because there isn't sufficient circumstantial evidence for the intent, but we know that they did an act which was so dangerous and they acted with depravity and reckless disregard for the life of another person. But the state can't prove the intent. It doesn't mean that the state has to disprove the intent. So it's a net, not a barrier. So that's what they're saying here with this, okay? The Supreme Court stated that its interpretation of the without intent clause of the third-degree murder statute did not render the clause superfluous, noting that the clause differentiates the offense of third-degree murder from the more serious offense of second-degree intentional murder. NOOR acknowledges that, quote, the particular person requirement is not a separate element, but he argues that the particular person requirement is a key component of the depraved mind element. So he's got a citation indicating the particular person factor relates to a depraved mind determination. As support, NOOR cites several Supreme Court decisions indicating that third-degree murder does not occur if the death-causing act was directed at a specific person. And this is the current jurisprudence that a lot of people are relying on with their third-degree murder analysis. And this is where the Court of Appeals, let's be very clear. The NOOR case is a problem. It's a problem in the understanding of third-degree murder in Minnesota. That's why so many attorneys actually do not believe that the third degree was the right charge. It's because a cursory look or even an in-depth look at the jurisprudence that is recent is going to show that third-degree murder should really be directed at more than one person because they're reading these cases. They're going to talk about why, but this is a problem for kind of the general understanding of it. All right? Okay. For example, in State versus Hansen, the Supreme Court stated that under Minnesota law, third-degree murder occurs only where death is caused without intent to affect the death of any person, a phrase which under our decisions excludes a situation where the animus of the defendant is directed towards one person only. Seems pretty clear, right? Later, in State versus Wahlberg, the Supreme Court stated that third-degree murder was, quote, intended to cover cases where the reckless or wanton acts of the accused were committed without special regard to their effect on any particular person or persons. The act must be committed without a special design upon the particular person or persons with whose murder the accused is charged. And more recently, in State versus Zumbergi, the Supreme Court stated that third-degree murder cannot occur when the defendant's actions were focused on a specific person. So again, all of these seem pretty straightforward. However, Angry Baneling, stop. Stop. I know what I said. It will be co-hosted on my archive channel, not co-streamed. It will be hosted there, but it will stay up here. Please, chill out. Okay. The cases on which NOOR relies. So here's where the Court of Appeals draws a distinction. The cases on which NOOR relies do not involve post-trial appellate review of whether evidence was sufficient to sustain a conviction of third-degree murder. Instead, those cases discussed third-degree murder in the context of jury instructions. Specifically, the defendants in those cases argued that they were entitled to an instruction on a lesser offense of third-degree murder. Okay? So they were charged with a different case or a different type of murder, and they were entitled, they're arguing, to a lesser included offense of third-degree murder. In each case, the Supreme Court disagreed, reasoning that there was evidence that the defendant acted with an element of intent not contained in the third-degree murder statute. This is a pretty big distinction that the Court of Appeals is making. They're saying that they're not arguing for, let's see. How do we figure this out? Okay. And this kind of goes against the Chauvin case a little bit, or could be argued. It depends on when they, have to come up with jury instructions for it. But they're arguing that they're entitled to this instruction. Let's say they're all charged with second-degree murder. They're entitled to this instruction that says, or third-degree murder, if this. And the Supreme Court says, in these cases, third-degree murder isn't merited because the evidence suggests that the intent elements of second-degree murder are met. So we're not going to have the lesser included offense. That's the distinction that they're making here between them and NOOR. All right? So, let's see. Here we go. So, C. Zumbergi, concluding that the defendant's own testimony demonstrated a specific intent to stop the victim, which precluded a third-degree murder instruction. So that was, a particular design upon a particular person. Wahlberg, concluding that the district court did not err by refusing to provide an instruction on third-degree murder because, quote, there was ample evidence to support a finding of an intentional killing, whereas third-degree murder is an unintentional killing. And then Hansen, concluding that the defendant was not entitled to an instruction on third-degree murder because there was sufficient evidence showing that the defendant acted with an element of intent not included in third-degree murder. We therefore understand those cases to mean that depraved mind murder does not occur if the death-causing act was directed at a particular person with intent to kill. And that is a critical distinction in these cases. Remember, in both arguments for Chauvin, under the second and third degree statutes that he's charged under, he is charged with the unintentional killing of George Floyd. All right? So in the second degree statute, he's charged with an underlying felony causing the unintentional death of George Floyd. And in the third degree statute, he's charged with basically acts so eminently dangerous done with a depraved mind that they caused the death unintentionally of George Floyd, but with no underlying intentional act. So the distinction between them here is whether or not Chauvin intended an act which was either a felony or not. That's the long and short. If he did a felony assault against George Floyd, because maybe they go with he unreasonably used excessive force, and that caused the death of Floyd, that's second-degree murder. If they can't get there, but they can show that his acts were so imminently dangerous and he acted with a depraved mind towards Floyd, then that's third-degree murder. So it's a weird situation, and they're drawing a distinction between these other situations. The cases on which NOOR relies do not involve post-trial appellate review of whether evidence was sufficient. Wait, I just read that whole section. Let's go back down to here. Okay, so that's their understanding. This sentence summarizes it right there. We therefore understand those cases to mean that depraved mind murder does not occur if the death-causing act was directed at a particular person with intent to kill. So they're ruling out all of that Supreme Court law on the third degree murder statute. So here, the issue is not whether NOOR acted with intent to kill. The issue is whether the evidence was sufficient to prove that NOOR evinced a depraved mind without regard for human life. As noted above, it is not necessary that more than one person was or might have been put in jeopardy by the defendant's reckless act. And the third-degree murder statute's reference to perpetration of an act imminently dangerous to others does not preclude its application when the death-causing act endangered only one person, because in construing statutes, the singular includes the plural and the plural includes the singular. As explained by one leading legal scholar, convictions of depraved heart murder can be based on conduct endangering a group of persons or only a single person, and that's citing substantive criminal law. Collecting cases upholding convictions for depraved heart murder, including those in which convictions were based on throwing a beer glass at a person who was carrying a lighted oil lamp, playing a game of Russian roulette with another person, and shaking an infant. So there we've got some case law backing that up. Because the third-degree murder statute does not require that more than one person be put in jeopardy, and the Supreme Court in Michtic upheld a conviction of third-degree murder even though the victims were known to and targeted by the defendant, we cannot say that NOOR's third-degree murder conviction is invalid simply because his dangerous act was directed at the single person outside of his partner's window. We are also influenced by our Supreme Court's recent statement in Hall that the phrase, quote, without intent to affect the death of any person in the third-degree murder statute serves to differentiate the offense of third-degree murder from the more serious offense of second-degree intentional murder. Indeed, Minnesota's second-degree murder statute sets forth two forms of murder, intentional and unintentional, and that statute twice uses the phrase without intent to affect the death of any person to describe circumstances constituting unintentional murder as opposed to intentional murder. The Supreme Court's interpretation of the cause without intent to affect the death of any person is consistent with and provides context for its early statement in Lowe that it is necessary that the act was committed without special design upon the particular person or persons whose murder the accused is charged. The phrase special design stems from the charging statutes in Lowe. Remembering Lowe is from 1896, so the language of the law was a little different, which provided that the killing of a human being, unless it is excusable or justifiable as murder in the first degree, when perpetrated with a premeditated design to effect the death of the person killed or of another. Such killing of a human being is murder in the second degree when committed with a design to effect the death of the person killed or of another, but without deliberation and premeditation. And then such killing of a human being when perpetrated by an act imminently dangerous to others and evincing a depraved mind, regardless of human life, although without a premeditated design to effect the death of any individual, it is murder in the third degree. So they're pointing out that in the old, the reason they have this design language in that old case is because of the design language in the statute. The design to effect the death clause of the murder statutes in Lowe is similar to the intent to effect the death clause in Minnesota's third-degree murder statute. Neither statutory clause creates an element of third-degree murder that the state must prove. They simply differentiate amongst first, second, and third-degree murder. That's citing Hall, or no, that was citing, citing Hall, comparing the intent elements of first, second, and third-degree murder. Indeed, the Supreme Court statement in Lowe requiring an act committed without special design upon the particular person or persons with whose murder the accused is charged indicates the court was simply describing a lack of intent to kill. The acts and omissions here in question are not of that character. They had special reference to Clara Berg. Like the Supreme Court, we conclude that the phrase without intent to effect the death of any person serves to distinguish unintentional third from intentional second-degree murder, and that the defendant's intent or lack thereof is the relevant distinguishing factor. The phrase does not preclude the possibility of a third-degree murder conviction if an unintentional death is caused by an act directed at a single person. In sum, we are mindful of the statements in jury instruction case law stating that a conviction of third-degree murder is not possible if the death-causing act was directed at a particular person. But other Supreme Court case law indicates that a third-degree murder conviction may be based on conduct directed at a single person and even a targeted person. We therefore hold that a conviction for third-degree murder under the statute may be sustained even if the death-causing act was directed at a single person. Thus, the evidence could be sufficient to sustain the jury's finding of guilt, even though NOOR directed his death-causing act at the person outside of the squad car's window. I know that's a mouthful. I know that's a lot to take in and consider, but let's see if we can break that down a little bit. Let's see if we can deal with that a little bit. And then apply it to George Floyd and Derek Chauvin. So, synthesizing all of that. We have to go and say that under current case law, this is being appealed. This decision that we just read is being appealed to the Minnesota Supreme Court. So this could all be nullified by an act of the Minnesota Supreme Court. However, that is potentially a year or more away if they take the case. So that is one of the issues with appealing to their to the possibility that this will happen. Chauvin's trial should be well finished by the time that the Supreme Court of Minnesota might render a decision in NOOR's case. And if he's convicted under third-degree murder, and if this particular decision is overturned by the Minnesota Supreme Court, Derek Chauvin will likely have a strong challenge to his conviction in this case. If those two things occur. Mind you, any conviction that he gets going to be appealed. That's definitely going to happen. But I just wanted to point out that if the Supreme Court overturns this Court of Appeals decision in State versus NOOR, then there's a very, very strong argument that a third-degree murder conviction for Chauvin is not justified. So let's make sure that that is out in the open. Now, let's take sort of the synthesis of what we just went through and summarize this into the Chauvin case, okay? If Chauvin acted without the intent to affect the death of George Floyd, a particular person, if he acted without the intent to inflict death on George Floyd, and his acts were reckless, were with reckless disregard to human life, and were done with a depraved mind, then he's guilty of third-degree murder under this reading of the case. Now, again, everything's going to get mucked up with jury instructions and with the jury itself. This is not a clear, simple application of law to facts that we can do in an academic setting. That's not how we do criminal justice in the United States, and there are pretty good reasons for that. So, that is the statute. If he acted with an intent to harm Floyd, particularly, if he acted with the intent to harm Floyd, and he went above his justifiable use of force as a peace officer in effecting the arrest of a person and went into excessive force, then he's guilty of felony murder, second-degree murder. That would be an underlying felonious act that resulted in the death of a person. If he did that, it's second-degree murder. If he did not do that, but rather he created a situation that was imminently dangerous to George Floyd's life, it's third-degree murder. So I don't know how else to explain that or break it down. That's the simplest sort of thing. One of the things that would be interesting would be the idea that he directed his acts at George Floyd because he was George Floyd, not because he happened to respond to the call. Those are different things. And we do know that there is at least some allegation, some hint of evidence that may come out at trial that George Floyd and Derek Chauvin knew each other due to some sort of, I'll call it extracurricular, but security work where they both worked at the same club at the same time providing, freelance security services. Now, whether or not that's true, whether or not they knew each other, whether or not that evidence will be admitted or will be brought, that right now is a report. That's a report from some sort of media source, and whether or not it's true will have to be determined at trial to be of any value. Okay? So that's what's going on over there. And if that's the case, if they can prove a direct connection from Floyd to Chauvin, then they may be able to eliminate the third-degree murder charge by saying, no, he singled him out, which would be a weird thing to argue, but it is sort of a possibility that he had a pre-existing relationship and his acts were designed towards George Floyd with particularity. There will, of course, be other arguments over what the officers knew at the time they're responding to the call, and in particular, what Derek Chauvin knew about George Floyd's criminal history and stuff like that. Those factors are going to weigh into this argument about the particularity of the actions. Okay, that being said, I hope this has helped you understand why the third-degree murder charge is in there. It does seem a lot like doublespeak, but the Court of Appeals in Minnesota is drawing a very big distinction between whether or not the evidence shows an intent to kill a particular person and then the jury instruction cases that the Supreme Court had issued on the subject, where they found that those cases were more about the intent leading to a conviction of a higher crime than including the lesser charge. So this is a little bit different than that. I don't know. I hope that's helpful. Let me answer a couple questions, and then we're going to wrap up this stream. This is a short one today, or during the daytime. We should still have a live stream tonight. It says, Angry Bainling, I believe, says, please live stream during the trial. I do plan on live streaming the actual trial. I haven't been live streaming the jury selection process. One, because it's long and I don't know. But maybe I will. It all kind of depends on if I'm awake for it and stuff like that. We'll see. The Big Red Bear says, it's very obvious that the appropriate charge is third degree. People are just blind thinking first degree because it somehow shows the murder is more heinous. They're getting too emotional about the reality of the situation. I think there is some of that going on, but I do think a lot of it has to do with some people suggesting that third degree, under the cases that were cited in NOOR's brief that the Court of Appeals deals with here, it kind of looked like the Supreme Court did not favor the use of third-degree murder when one person was the target of the animus. And if the Supreme Court comes in and corrects the Court of Appeals and says, no, you read our cases way wrong, that could be the outcome there. And so that's why a lot of people think that the third-degree murder charge was inappropriate. I think the third-degree murder charge is appropriate. I happen to agree with how the Court of Appeals reads this. I might be wrong with them. I'm fully willing to accept that I might be wrong with them, but for now, that's the way it's going. Someone earlier asked a question about the spark of life, which was brought up in the jury questioning. Now, I'm not familiar with the exact context that the spark of life statement was used, but generally, when you're talking about spark of life evidence, it's this balancing act, okay, where the prosecution has an opportunity to show a quote unquote spark of life in a victim, right? In a deceased person generally, that they're more than just a corpse on a gurney. They're more than, I think the court in Minnesota worded it, they're more than bones covered in flesh, that there was something to the life of the person. They have to walk a very fine line on using this spark of life evidence, because they cannot use that evidence to make a prejudicial case against a defendant on behalf of a victim. So what they can't do is show, oh, look, this guy, all he did was voluntarily save kittens from trees all day, every day. Aww, right? Like they're not doing that. They can't make a hero or a martyr out of a person. And that's the spark of life evidence. They can show enough about the character of the deceased to make them into a real person rather than just a corpse or a statistic. But they cannot go beyond that. If they go beyond that, it risks a mistrial for prejudicing the defendant. So I hope that answers the question on spark of life. I don't have the context it was asked, but that's what it's going to be around. And if there was, I heard there was some, sort of deification of George Floyd by some proposed juror, calling him Jesus or something. That goes beyond the spark of life, and that person shouldn't be allowed to be a juror. That's where that is. So, so there we go, guys. That's the third degree murder. This is not intended to be a very long live stream. I think we're coming in right at 45 minutes. So we're going to go ahead and wrap up. Thank you for hanging out today. I'm going to try and do more of these sort of midday 30 to 60 minute live streams in the future, because it's a nice opportunity, either them or premieres, whichever. It's a nice opportunity to take a little bit of a deeper look into an issue and examine that issue. So thanks for hanging out with me with this, and we will see you next time. Have a good day. Again, you can come back for the live stream at 11 p.m. Should be fun, probably. There will be an announcement about what's in it later today. Have a good day. Peace. Peace. Wait a minute, the outro is supposed to play, but I screwed it up.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of that frog. The spirits flow as the ones who get unemployed. So pour out a glass for the deposed on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out an odd bag of bow, more of that Freud. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the wide shores of Nan to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law